The third and final appeal on this afternoon's calendar is the people of the state of New York versus Nicholas Hill.
Good afternoon.
My
name is Susan Epstein from the Legal Aid Society, and I represent Mr. Nicholas Hill. The question in this case...
Counsel, would you like to reserve any rebuttal time?
Oh, my gosh, yes.
Of course.
I'd like to reserve 1 minute.
Of course.
The question in this case is whether Mr. Hill was seized when the police took his photo identification away from the scene of the encounter to conduct their investigation.
Counsel, is it your position that that alone, that scenario, he's waiting there, they go take the license and they do whatever they do with it in this investigation, that alone is a seizure, or is it in combination with the other circumstances here?
I think that alone is a seizure. And that's the threshold issue of law that's presented in this case. Is that a seizure?
Do the other circumstances make a difference, and particularly was told, stand here?
Well, those are sort of icing on the cake. I think even if he wasn't, I mean, yes, those are circumstances you can add on to the whole situation, and certainly there are cases where courts look at all the circumstances, but I think without anything else, if they say, who are you? Do you have any identification? Can I see your ID? And then they retain that identification?
What if the identification is a library card? Does that make any difference?
I think nobody's going to, I guess, with a library card.
Well, if it had a picture, it's, and then they're trying, supposedly, the purpose is to bring it up to the resident and say, do you know this person? So if there's a picture, it looks just like him, and it's on a library card.
Well, there's a benefit to having a library card, and I guess it's for this court to draw the line to what type of identification.
Would the temporary taking of that card lead someone to feel that they couldn't leave? That's the question.
I think so. I mean, if it's a card that gives them a benefit that they care about, they're going to feel...
But they could replace that kind of card. I mean, it seems to me that, if you have a driver's license or something, then, that's different, because maybe you can't go get in your car and leave because they have your driver's license or your Social Security card or something like that, which, so...
Let me ask it a slightly different way.
Sure.
What if you have several IDs? You work for the government, you may have several. You may have the driver's license, you may have the governmentally issued ID to get in the building, you may have some other kind of ID, and you only turn over either the library card that perhaps is not as important to your work to driving, or you turn over one of these and you still have other ID.
Well, I haven't had a library card in a long time, and there weren't any photos on it then.
I don't know that they have library cards anymore, but let's go with it.
But
You get
with
the
any
point.
kind of an ID, let's assume that an identification with a photo on it, generally in our society, is used to obtain some benefit, to obtain some access.
Yes,
It
but the question
requires-
then is whether or not, if you have other IDs that allow you to, at least for the next 48 hours, to function, is it really a seizure
I think
if you
so.
could probably get that ID that was taken within 48 hours?
Why would
Or
you?
less.
Why would you want to have to be? I can't imagine any situation. I mean, I could, if I was at Macy's and they were holding my Macy's card. I think I'd want to get my Macy's card back before I left. Sure, I can call and say, cancel it, somebody took it, I don't have it, I need a new Macy's card. But why should I? That's my property. And my instinct is going to be to say, I want to remain until I get my property back.
But in that example, you're free to walk away. You come back an hour later,
You're
right?
free to walk away. But
that's the question.
The question is whether a reasonable person would feel free to walk away. And in this, we're in a police versus citizen encounter, okay? And that's what the Fourth Amendment is all about. It's not about...
Counsel, how does the defendant's testimony, if it does at all, I want your view on this, at the suppression hearing that he offered to accompany the police officers upstairs, how does that play into our analysis of the
Well, the court
analysis?
discredited his testimony and just didn't believe any of that. I don't think that plays into anything, because the fact is, this is a very narrow question. The only question, which was preserved by counsel at the hearing, whether he was restrained by the police when they took his ID and actually removed it from the scene. We don't know if it was a driver's license. We can tell it was a photo identification because the officer who brought it to the apartment actually said, "Do you recognize this person?" In all of the cases that we've seen around the country, it's never been specified what exactly. Sometimes it's a driver's license, but it's just generally been an ID. And identifications exist for a reason. They're important to you for certain benefits that you enjoy or certain rights you want to exercise.
Does the duration of the removal or the purpose of the removal or both or neither matter?
The duration does matter, and the purpose, yes, absolutely. I mean, this was a level 1. And in level 1, you're allowed to request information, ask non-threatening questions. What's your identity? What address do you live at? Where are you going?
If this were a level 2, would the police have been allowed to take the identification?
I think that once they're retaining it, the fact is, from the identification, what are they going to get besides your name, your address, maybe your driver's license number? Once they're holding that, it's just like holding an extension of the person.
But you just said that how long they have it matters.
Yes, it does.
So then how is it a per se rule? Is it a 5-second rule? Is it a, if they walk out of your eyesight rule? What is the rule that you're asking?
I think the rule is
us to-
that they're allowed to use it for the purpose in which it's being offered, which is to identify the person. I think once they've had it long enough to say, yeah, that looks like you.
Well, how
Have
long
you
is
dyed your
long
hair?
enough, though? So is it?
Well,
isn't
one
that-
court, actually, I think it was the 10th Circuit, found after 5 minutes, they really didn't need it anymore to ascertain he was the person they were talking
Well,
to.
here the court said it was brief, and we don't know how long it was.
Well, we
So how
know
can-
it was
how can
several
we-
minutes. I mean, they had to take it up into the building, on the elevator, up to the 11th floor, talk to somebody, then take the elevator, assuming it came right away, down, and come back over.
So how many minutes does it take to be a seizure?
I think it's, I think if it's going to take more than 5 minutes for them to look at the ID and say, that's you, and I know everything I need to know
So
about
if it's 5
you.
minutes and 10 seconds, then it's a seizure, but if it's not, then it's not a seizure?
Let's just say retain longer than necessary to identify the person,
well,
which
in-
is what it's being used for.
In this case, there's an indeterminacy, really, because the officer could, I think it's Officer Eng, goes up, and he may have to do more than just go to that one apartment
True.
that he's been designated to go to. He may make some discretionary determination that he needs to knock on some other doors, he runs into, he may get distracted.
True.
There may be an emergency in the building, unlike when you stop the car, which is a seizure anyway. You stop the
right,
car.
that's a seizure.
You go back to the police car and you're checking the license. There's a certain finite amount of time.
It's open-ended in this case. It was
Well,
open-ended.
You could apply some sort of objective reasonableness standard, I think, though, as far as the time goes. We didn't have to get bogged down in that. I guess what I wonder is, if we apply that, are we into the mixed question of law and fact?
No, I don't-
territory? Now, let me just finish my thought.
Sure, I'm sorry,
Yeah,
Your Honor.
No, it's okay. And the reason I asked that way is because, in other words, I'm really asking, is this beyond our power to review this in the reasonableness of the action? Go ahead.
No, I don't think it's beyond this court's power to review it. It's not a mixed question because it's presenting a threshold legal issue about whether a seizure has occurred. And there's no support in the record below for the court's finding that this was not a seizure.
See, I guess analytically, what I'm concerned with is the identification versus the investigation problem. So there's certainly a period of time that's reasonable to allow for identification and even maybe some modest investigation, like if you can call it saying that's the person in the ID, that's an investigation. How far does that go is a legitimate question to ask for any attorney. The question for us is that a mixed question or not? Or is there, and what objective standard would we apply to determine when it is and when it isn't?
Well, I think with all the legal rules and tests that I've seen, there's a certain vagueness involved. And I think saying that retention of an identification...
What your test would be?
My test would be retention of identification longer than necessary to ascertain the person's identity by looking at them and checking their name is too long. I think that once you're doing that, the person, as long as that officer, even if, really.
But how is the officer here going to be able to confirm that Brown, that Mr. Hill,
Mr. Hill.
excuse me, a lot of Browns going on, that Mr. Hill indeed knew someone in the building, because that's what he was arguing. His grandmother lives there, he has a key, right, whatever, his girlfriend is there. How else to do that without, if this is a picture ID, show the picture, not just the name, because
Well-
he could be using someone else's name.
Well, the great thing is, we live in the age of the cell phone. And I think just about every police officer has a cell phone, and if they don't, they probably should be given them officially. And all you have to do is take a picture of that ID, take it on your phone, and go up and ask the person. But the problem with what happened here is, while they conducted their investigation, he had to wait. He did not feel he could leave. And as long as he's being
Did he ever
made
say
to...
that? Did he, in any of the hearings, in any of the legal proceedings, has he ever said that he did not feel that he was able to leave?
He wasn't asked. So I think that's one thing. But we're saying the hypothetical reasonable person, because it's not a subjective test.
Well,
It's based on a reasonable
If he felt he could, he
person.
would have gone up the steps, right?
If
Wouldn't
he
he,
what?
wouldn't he have gone with the officer? Show them
He
the
probably would have
apartment?
said, give me my ID back, you can't take it upstairs, I'm leaving now. but-
Or he could have gone with them.
Or he
If he
could have
really
gone
thought
with
he could have
them.
left.
But you know what? The question that we're presented with is whether holding on to this identification, and in this case, if you want to make it this narrow, removing it from the scene constituted a seizure. He wasn't even in a position to say, give it back to me, because it wasn't even there anymore. So it was just this, well, when is my ID coming back? I mean, if you want to make it that narrow. But what about a situation where you're standing there with a few officers and, okay, I got your ID, I'm going to go back to the car and I'm going to run a check on this. He's waiting there. As long as you're holding it in that car, he has to wait. That's the reality of modern life. That's how important ID is in modern life. And nobody wants to relinquish their identification. Everybody's worried about identity theft. You're just going to leave your identification floating around somewhere? It's the identification was just for a level 1 inquiry. And what really happened is he was coerced into waiting there by them holding on to it and taking it away
So
from
your
him.
view is if the officer radios in the name to see if there's an outstanding warrant, that's a seizure?
No, I think if he's holding on to the ID the whole time he's doing it, take a picture with your cell phone,
No, if
go
if
back
he's-
to the
if he
car.
takes the ID, holds on to the ID, and has a handheld radio, let's say, and radios that in, that's a
Well,
seizure of the person?
It's sort of interesting because isn't he doing an investigation at that point?
That's why I was asking about the duration of the purpose.
Well, in that sense, I think once you've gone beyond ascertaining that's Mr. Nicholas Hill, this is exactly what he looks like, once you start doing other things, give him back the ID and then do your investigation. Because as long as you're holding that card, he can't leave. And you're now extending it into an investigation that may grow even longer. He doesn't have the freedom to leave. And that's all, he is supposed to have the freedom to leave at a level 1. And he's just being compelled to stay there.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, John Hughes for the people.
Counsel,
Good afternoon, Your Honors.
Why aren't we talking about level 2 here?
Well, Your Honor, again, so even in DeBoer itself, and People v. Holman as well, this court held the police can ask for identification as a part of a level 1 inquiry. And of course here...
It seems to me this went a bit beyond that. I mean, clearly they were doing some investigation into criminality so...
Well, Your Honor, I'd say in the first place, defendants' claims have always only been focused on level 3, on whether or not this actually constituted a seizure or not. But here I would note, too, that the police, they never asked the kind of accusatory, threatening questions that normally implicate a level 2 analysis under DeBoer. Again, defendants' claim here, too, has also always been based on their level 3. But I would also argue, I would also note too, the prosecutor did argue that, when the defendant is giving his answers to the officer's request for information under level 1, she did argue that those answers did elevate the level of suspicion and then justify the officers going and verifying defendant's claim with the identification. Now, again, she's making these arguments in a more general sort of under the general DeBoer analysis of, was this reasonable, were their actions justified and everything. But I think the fact that
It seems that they were asking, they were trying to gain explanatory information, and it was more than just your name, address, and, what are you doing here?
Well, respectfully, Your Honor, I think under People v. Holman and DeBoer as well, this court has made it clear that the police can ask what's someone's reason for being in an area, where are they going, what's their destination, and then also asking for ID, and this is all completely proper under level 1 of DeBoer.
Well, if we disagree with you, do we have to then send it back for determination? Because that determination was never made as to whether the requisite level of suspicion was present for a level 2, right?
Well, Your Honor, again, in the first place, I would say, defendant never argued that, at the point when Officer Ng is taking the identification upstairs, defendant never argued that if that did require founded suspicion, that the police didn't have it. So that's the first thing I would say. But again, also, I think the prosecutor, I think this court could affirm on that basis because the prosecutor did argue that, in response to these level 1 questions, defendant's answers elevated the amount of suspicion. She does say that at one point. And so I think, obviously, if you're at level 1, and a level of suspicion is elevated, where do you go from there? You go to level 2. But also, more generally as well, I think all the court's questions thus far really illustrate how much of a very fact-specific issue this is. We're not disputing that the retention of an identification is a factor that the hearing court can consider in these kinds of cases.
And you're not disputing the fact that Mr. Hill was told, stand right here.
Well, Your Honor, I think if you look at all of the record around the issue of about him standing by the gate, even defendant in his own testimony, when he describes it, he says, "Oh, I got up from where I was sitting, and I was standing next to a gate when I'm talking to the officers." Even defendant himself didn't characterize this as him being ordered to stand by the gate.
Well,
Also,
but to stay in place, not necessarily move to the gate, but I think the officer said, I told him to stay there.
Respectfully, Your Honor, I don't think that's quite how they phrased it. At one point, Officer Aguilar, I believe, said, "Yeah, I believe we brought him over to the gate." Said something along those lines. Again, this testimony was somewhat equivocal, but Officer Aguilar also specifically testified at this point, defendant could do whatever he wanted and was free to leave. And so, given that both Officer Aguilar and even defendant in his own testimony, they aren't really characterizing this as him being ordered. But also, with all these
Sounds like that
individuals.
would have escalated a little suspicion if he actually tried to leave at that point. I'm not sure I'm understanding that part of your argument, but let me ask you something else. Let's say he did leave.
Yes.
What information did he have so that he would know how to get his identification, get it back?
Well, Your
So
Honor,
he's left, an officer has it, an officer is left with it. How would he get that back? What would
Well,
he
Your
have to
Honor,
do?
I think he'd go to the local precinct, for instance, and say, "Oh, hi, it's having this encounter, but I had to leave. Do they have my identification? Could I get that back?"
Isn't there an air of unreality to these arguments, sort of? I mean, nobody's going to go and get their... If you stop a kid in front of a housing project in New York and you take his license away from him or some form of ID, and then he takes off on it, he's not going to go to the police station to pick it up later. There's this kind of an air of unreality that the law engages in here, too, and that may be why sometimes we're forced to rely on mixed question of law and fact, because the practical realities are somewhat different. What I'm wondering about is, they took the ID to confirm his identification. Now, but it seems that the ID was then used to confirm his reason for being on the property. Would you say that that's an accurate
Yes. When Officer Ng takes the ID upstairs, it's to verify his explanation for
So
why
when he
he's in the
takes the
area.
ID, does that cross over then into that line of investigatory / we're detaining you?
No, Your Honor.
And why not?
Well, because he can still walk away at any point if he chooses to do so.
That's where you're entering into an air of unreality for me. Isn't a more realistic response is that part of identifying them is seeing if what he says is true. Whereas the reason I'm here is I'm going to visit someone, they went to 11B, and the person might have lived at 11A, whatever. You see what I'm saying?
In what sense, Your Honor?
Well, what I want to know is it still within the identification realm, or is it moved into the investigatory realm? That's what I want to know.
Well, at this point, certainly when they're taking ID upstairs, it is not just to verify, who this person is. It is pretty clearly to verify whether or not he's actually a guest
So
here,
does
whether
that
or not he's
level,
trespassing.
does that change the level of the DeBoer analysis then?
Oh, not necessarily, Your Honor.
Why not?
Well,
Isn't
because
that acting on a founded suspicion?
Well, in this case, Your Honor, again, if it's possible to request ID as part of a level 1, I think that certainly implies.
You're totally right. We all agree with you on that. Okay. But to the next level, which was what Judge Stein's point was, aren't we really moving into the realm of founded suspicion here?
Well, again, Your Honor, just because level 2 so often involves these more accusatory questions, that you really didn't have anything like that here. And again, as the appellate division decision pointed out below, it's clear from context what's going on at every point. It's clear, it's clear to all of the police and defendant what they're doing with this identification. And still, defendant isn't objecting to this.
They're trying to determine whether he's a trespasser or invitee, right?
Yes, that's why the ID is being brought upstairs. Yes, to
Right.
very quickly verify whether or not he's actually is it trespassing or not.
Counsel, could you speak to the suppression issue? I know you make that point in your brief. So let's say this is an improper seizure, and then later they have probable cause to arrest. What's the effect on the drugs that he has on him in terms of seizure, in terms of suppression, I'm sorry?
Absolutely, Your Honor. So here, just the mere fact that defendant may be waiting outside in the interim, outside, that doesn't change the fact that Officer Ng gets upstairs and discovers that,
Let's say that's an improper seizure. Does that change the facts? Assume that for now. It's an improper seizure. They go up, they do this independent investigation, they get probable cause to arrest, they come down, they arrest.
Well, the officers who were standing outside with defendant in the interim, just while he's standing out there, they don't really produce any other incriminating evidence.
There's no
Again,
statement, there's nothing like
right,
that.
there's no other statement, so they don't get any other incriminating evidence from just the mere fact that he's sitting there and waiting outside. And also more broadly, I think it's important to note, too, that the police conduct here was very reasonable. And that's really the crucial factor in any DeBoer analysis. Because here, based on all of the police's initial observations and based on defendant's answers to these questions under level 1 of DeBoer, I think the police would have been justified in seizing him immediately, but they didn't. They didn't frisk him. They didn't jump to conclusions. They didn't immediately arrest him. Instead, they took this minimally intrusive step of asking for identification. Defendant agreed to give it to them, and then they took it upstairs very briefly just to verify his reason for being there. So this is really a case where the police are acting exactly how we would want them to do.
Let me add, and I don't remember the record, so I'm asking this question of
Sure.
you in that light. When they ask for the ID, is it obvious that they're going to walk away with it?
I think at the very
Is that
least,
his understanding? Have they communicated to him, we want it because we're going to go and check?
I think perhaps when they first requested, it might be unclear, but I think it very quickly becomes apparent why he's doing that.
But it's after he's turned it over, correct?
Well, the police have been asking him about, are you visiting someone here?
Right.
And soon after that, they do take it upstairs. So again, the police may not have been very explicit with that, but as the appellate division recognized, based on all the surrounding circumstances, I think any reasonable person would understand exactly what was going on.
When they stop me and say, what are you doing here? And there's more conversation and I turn over my ID, that he understood, or a reasonable person under those circumstances would understand that the police are now going to take this ID away from that scene for who knows how long to go into the building. You think that's what he understood?
Well,
The person would understand that?
at the initial request for identification,
Yeah.
that might not have been entirely clear right away.
But that's the point, right? That even if we go with your suggestion here, that it's voluntarily turned over, which it is, it's for that purpose. It may not necessarily be for every other purpose.
No, again, but defendant in his own testimony, he never claimed that them taking upstairs, because of that he felt like he couldn't leave, in the first place. But also when the ID is being taken upstairs, I think it is readily apparent what's going on. And again, at that point, he doesn't object and he doesn't say, "Oh, actually, I need to go. Can I please have my ID back?" And just broadly speaking as well. even though if someone's being interviewed in a police precinct, for instance,
Did he need to do all those things? What if he's told stay up against the fence and he doesn't say anything? He's afraid to say anything.
well, again, Your Honor, the whole point of level 1 and level 2 under DeBoer is that, of course, there's always some intimidation inherent in any police encounter. But, level 1 and 2 of DeBoer exist so that under the assumption that a reasonable person, can say yes or no to various police requests, and that, they can agree or not agree to do certain things. And so, here, even if, because of social pressure or some other reasons, someone, might agree to whatever the police are doing, that doesn't necessarily mean that a reasonable person wouldn't have felt like they couldn't leave if they chose to do so. I see that my time is up, and thank you very much.
Ms. Epstein.
I think maybe it would be helpful to think about this outside the public housing context. Let's say, one of you is walking down the street, and it turns out, unbeknownst to you, there's been a burglary in the building you're just happening to pass by, somebody described wearing a black robe. So the police come up to you and say, "Excuse me, what's your name?" "Oh, okay, may I see some ID?" "Okay, thanks. Okay, Joe, go upstairs and see if what they have to say about this." Now you're standing there, okay? How long are you standing there waiting? Are you going to leave? It's just you. It's not a person in a housing project. This is a very basic question. It's about police seizing somebody by taking their property, a property that has some significance, and retaining it without really forcing the person to say, "I want that back."
In that circumstance, I've definitely handed over my judicial ID and not my library card.
Okay, and then you'd be okay. But, it's troubling. It's one thing when you look at this in the housing project context, but when you look at this could happen to anybody at any time. This could happen with your driver's license. And really anybody you ask on the street is going to say, "Oh yeah, I'd have no problem if they took my driver's license. I'd leave. Pff, who needs that?" You're not going to leave. You're going to stay there until you get your license back. And you might be intimidated into saying, "Can I please have my license back now?" It's a tough question to ask. And we have to look at it beyond just this context, because it can occur in a variety of contexts.
Thank you,
And
Ms. Epstein.
You're welcome. Thank you very much.